3 questions. The first question is as follows. What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labour Act? And how does that classification determine whether arbitration is voluntary or compulsory?
Thank you, Chief Justice. Part A, a dispute of interest is a dispute whereby parties are having a disagreement concerning an entitlement or benefit which has not yet accrued to the party, and a dispute of right is where the parties are having a dispute or disagreement over an existing right which might have accrued from the Labour Act, contract of employment, or collective bargaining agreement. Part B, the classification is important in determining whether the dispute will go for voluntary or compulsory arbitration, because if it's a dispute of interest and the parties are in essential service, then the matter has to go for compulsory arbitration automatically. But if it's a dispute of interest and the parties are not in essential service, the matter may only go for compulsory arbitration by consent of the parties. And if it is a dispute of right, the matter may only go for compulsory arbitration if the parties agreed or if the presiding officer makes that determination. Thank you.
Yes, you may switch off your microphone. The second question is as follows. What steps must a Labour Court judge take to properly address and decide a constitutional question arising during its proceedings, if any?
Thank you, Chief Justice. The first part, Part A. Sorry, it's only one question I had written to quite, sorry. When the constitutional question arises during the proceedings, a Labour Court judge if requested by the parties, must refer the matter to the Constitutional Court, unless if in his or her opinion the question is merely frivolous or vexatious. If he determines that the question is not frivolous and vexatious, the judge would hear facts, submissions of facts from the parties, and determine on the issues of facts. If there are no contestations on facts, then he may ask the parties to write a statement of agreed facts. If the judge has meromoti decided that the matter, or meromoti decided to refer the matter to the Constitutional Court, he should also ask addresses from the parties to address him on the issue of facts so that they can be resolved. After that, the judge should determine the issues of fact, and also the judge should also clarify the constitutional questions and state them in concise manner, accompanying his referral to the Constitutional Court. He should also make sure that the record is prepared, including the proceedings which were before him, in which the question arose, and also make sure that all the records are prepared in the required number of copies so that the record can be referred to the Constitutional Court. Thank you.
Just to clarify before we move on, is it your position that the judge has to decide whether the question is frivolous or vexatious?
Yeah, yes, CJ, he should decide whether the...
No, yeah, is that your position?
Yes.
All right. The third question is as follows. What is the appropriate test for determining whether the Labour Court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labour appeals?
Thank you, CJ. I kindly request that you repeat it. Yes.
All right. What is the appropriate test for determining whether the Labour Court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labour appeals?
Thank you, Chief Justice. The test is called irrationality test. The court has to ask itself whether the conclusion which was reached from the facts is so gross in its defiance of logic that no sensible person would have reached that conclusion after looking at the facts. Thank you.
Yes, I'll now pass you over to the other commissioners for further questions if they have. Yes, CJ.
Yes, thank you, Honorable CJ. Good afternoon, Mr. Peiwa.
Good afternoon, Deputy CJ.
Yes, I have one question for you. Given the scope of the matters that appear before the Labour Court, can you list the possible agents that may represent parties before the court as highlighted by the Labour Act, Chapter 2801?
Thank you. The first agent to represent the party is a legal practitioner registered in terms of the Legal Practitioners Act. The second one, an official from a trade union or its employee to which the party is a member, and if it's a company secretary, director, human resources officer, or some other selected officer of that company. Thank you.
Thank you.
Thank you, Chief Justice. Yes. Morning, Mr. Mpeiwa.
Morning, Commissioner.
Yes, Mr. Mpeiwa, as Regional Magistrate, can you tell the Commission to what extent you have interacted with the Labour Court?
Thank you. From the time I became a Regional Magistrate, I did not interact with the Labour Court.
Thank you. May I refer you to your questionnaire, where you indicated that in the last 10 years you have interacted with the regional court by way of registering and enforcement of Labour Court judgments. Do you recall that?
Yes, I recall it.
Is that correct?
I think I did not express myself clearly. I wanted to say I dealt with registering the awards 10 years back.
Yeah, but the question was very clear. In the last 10 years, can you describe your interaction with the Labour Court? And you put that information, which is not impossible. You agree with me that as a regional magistrate, you don't deal with such civil cases?
Yes, I agree, Commissioner.
So you misled the Commission as you filled in that form?
the information did not come out correctly. The information is misleading, but I did not intend to do so.
Okay. And still on professionalism, as a regional magistrate, can you tell the Commission whether it's possible for a regional magistrate from one province to hear a matter from another province? Is it possible?
Thank you, Commissioner. Generally, it's not possible, but there are exceptions.
What are the exceptions?
If it's a matter of theft or other offense of which a person has obtained a property through that offense and taken that property to another division, and that property is found in that other division, then the regional magistrate has jurisdiction to hear the matter because of Section 56, subsection 4 of the Magistrate Act.
Have you found yourself in such circumstances?
Yes, Commissioner.
Can you briefly describe to the Commission? In fact, maybe let me lead you. I wanted to find out simply that on what basis did you deal with a matter from Mashonaland Central Province when you were stationed in Manicaland?
Thank you, Commissioner. The matter was not from Mashonaland Central Province. It had occurred in Norton. A person had robbed someone in Norton and drove the car. He had robbed a car. He drove it to his home area in Wenges, which fall under Mutare. So what happened is that he committed another offense in Mutare, which was placed before me. I dealt with the trial. It was a contested trial. After I was done with the trial, it came out that the car, which the police found him in possession of, he had been stolen from Norton. So they brought the docket again. And I actually inquired from him. I wanted to confirm from him if he's still comfortable for me to handle with the matter since I had dealt with another one. Then and I also told him that the matter can be dealt with in Harare or here in Mutare. If you want, we can send it to Harare. Then he said, no, I am pleading. You can deal with my matter here. That's how I dealt with the matter.
Was that matter brought to your attention by any disciplinary tribunal?
No, it was not. What happened is that the judge wrote a query on that. I was on leave in January. I was on leave. Then I responded, and I actually responded through the cell phone to the other regional magistrate so that she can just correct the grammar and put the letterhead and then sign on my behalf and send it to the judge. That's what happened.
So you found it difficult to properly respond to the issue raised by the judge? From what you're saying, you simply took it very casually, so to speak?
No, Commissioner. I actually responded. I responded to that matter that day when I received the query, because it was sent to me via WhatsApp, so I had to draft my response via WhatsApp also and send it to Mutare and actually phoned my co-regional magistrate to make sure that it goes that same day. And that was done.
But all the same, as a regional magistrate, can you tell the Commission within what period must a magistrate respond to a review minute coming from a judge?
He should do so, Commissioner, within 7 days.
Have you done that?
Yes, I responded that same day. I did not take even 2 days.
I have nothing further, Chief Justice.
And good morning, Mr. Mpeyo. Right.
Morning,
Before
Commissioner.
I deal with my substantive question, there is something that I think I was left unclear about from your interaction with the Commissioner, the Attorney General. Now, the question she asked you relating to the information you gave the Commission is where I'm getting to. And in particular in relation to your interaction with the, you can switch it off for now. In relation to your interaction with the labor court. Now, I didn't understand how it came about that you say the information didn't come out the way you wanted it to come out. But you're a judicial officer, so words mean a lot for a judicial officer. So, would you mind clearing this air? Was it because you misread the question? And if you misread the question, what does that mean about you as a judicial officer? Is it that you did not pay attention as you answered? And if it's that you did not pay attention as you answered, again, what does that mean? In other words, put differently, the reason for the information to be given to us as it is not clear from your explanation. So I thought perhaps you should take the opportunity just to clarify why that happened and the meaning of that in relation to yourself.
Thank you, Commissioner, for giving me this chance to explain. I think I misread the question. And my answer, I wanted to say I interacted with the labor court 10 years back. That's what I wanted to convey. Because from the time I became a regional magistrate, I did not register any court orders from the labor court. So, as for your question, you said, what does it mean for a judicial officer? I think that is an area which I should improve on, to pay attention to details.
Now, for my substantive question, it follows. What are the potential legal consequences for an employee who resigns without giving proper notice, and how should the labor court interpret such a resignation under Zimbabwe's labor legislation and principles of fairness?
Thank you, Commissioner. The Labour Act is silent on the remedies available to the employer, but the employer he may resort to common law remedies, that is the breach of contract, or try to seek for specific performance. And if it comes to the labor court, I think the labor court should interpret that as an unfair labor practice, because the employee would have left without giving notice to the employer, especially when their employment contract states that he should give a notice. That's my answer. Thank you.
So that I'm left unconfused. Is it therefore your position that in circumstances described, an employer can seek a specific performance, which is the word that you used? I just want to confirm what you say.
I say maybe in other circumstances you may seek specific performance, but my gravamen of my answer was that he could seek for remedies in common law. The Labour Act does not have the remedies. Thank you.
Yes, Mr. Mopey, sorry, I would need to be a bit persistent about this. I used your words. And I want to understand whether that is your position, because you took a position. Now I want to understand that whether we want to confirm that position. that an employer has the remedy of seeking specific performance, whether it's in certain circumstances and not in other circumstances, but that's what you said. So I simply wanted to confirm that.
Yes, Commissioner.
Thank you very much, Mr. Mope, and thank you very much, CJ.
Thank you, Honorable Chief Justice, and good morning, Mr. Mpeiwa.
Morning, Commissioner.
My question to you comes in two parts, and the first part goes as follows. How would you construe the phrase redress any dispute in section 63(3)(a) of the Labour Act? And the second part, does that phrase permit a designated agent to entertain appeals on the merits of a determination or only to initiate conciliation?
Thank you, Commissioner. May you come again on part B of the question?
Sorry, I will take that again. My mic was off. The second part again. Does the phrase redress any dispute permit a designated agent to entertain appeals on the merits of a determination or only to initiate conciliation?
Thank you, Commissioner. On part one, my understanding of the word, of the phrase redress, means that he should hear the matter as a fresh matter, not as an appeal. Okay, I am coming to the second. He should hear the matter and also make a determination. Coming to part B, the phrase redress any dispute does not mean appeal. It only means that if he fails, if he initiates conciliation and then fails and then the parties fail to get to a settlement, he may then forward the matter to the next level.
And what would be the next level?
Thank you, Commissioner. Depending on the nature of the dispute, it might be a compulsory arbitration. It also might be an voluntary arbitration.
Thank you, Honorable Chief Justice.
Good morning to you.
Morning, Commissioner.
I do have one question for you. What mechanisms exist under Zimbabwean law to enforce the right to equal remuneration for similar work provided for under Section 65 of the Constitution of Zimbabwe, 2013?
Thank you, Commissioner. I can't recall the exact section of head, but there is a section which was introduced by the 2023 amendment to the Constitution, which specifically enforces that right, which says that an employer should pay equal remuneration to males and females in respect of work which is considered to have the same value and without regard to gender, sex. Thank you.
Is there a similar provision in the Act?
Yes, Commissioner, I read the amendment, amendment, 2023 amendment.
Referring to the Labour Act, is there a similar provision?
Okay, that's what I am stating, that I did not have the consolidated Labour Act. I have the amendment and the old Labour Act. So from the amendment, I saw the similar provision.
What recourse is open to an aggrieved party?
Thank you, Commissioner. The aggrieved party may raise that issue as an unfair labor practice because it is a discrimination. Thank you.
Thank you, Mr. Mpewa. Thank you, Honorable CJ.
Thank you, Chief Justice. Good morning, Mr. Mpewa.
Morning, Commissioner.
I'm going to ask you a two-part question. And the question is, under the Labour Act, what is a collective bargaining agreement? And the second part is, what are the prerequisites for its validity?
Thank you, Commissioner. The first part, the collective bargaining agreement is an agreement which is reached after negotiations between the trade unions, the registered trade unions, and employers organization, which is also registered, concerning conditions of work and also even touching on things like wages, minimum wages, and things like that. And coming to Part B, for this Part B, I will just hazard an answer. I am not so sure. From my reading of Section 74 going down, it would seem that the prerequisites for its validity is that the parties to the negotiation should have been registered, those who negotiate, and after they had come up with an agreement, the agreement should be registered by the Registrar of Labour, and also after that it becomes valid. But for it to attain the status of statutory instrument, the minister will also have to gazette it in the government gazette. Thank you, Commissioner.
Okay, thank you very much.
Thank you, Chief Justice. Good morning, Mr. Mpewa.
Morning, Chief Magistrate.
I have one question for you. How does Section 90, capital letter A of the Labour Act relax strict rules of evidence and procedure? And what limits remain to prevent injustice through procedural laxity?
Thank you, Commissioner. May you come again a bit fast?
Okay. How does Section 90, capital letter A of the Labour Act relax strict rules of evidence and procedure And what limits remain to prevent injustice through procedural laxity?
Thank you, Commissioner. Section 90A of the Labour Act provides for equity in the manner the proceedings before the Labour Court are handled. The judge is at liberty to decide the manner in which the evidence can be adjusted, which means he can decide whether the evidence can be brought orally or it can be adjusted as written statements. The judge may also make sure that the judge is actually mandated to make sure that the evidence is adjusted. So he is at liberty to call witnesses, to ask them questions, to also even ask questions from the parties. In that way, the Section 90A, it relaxes the adversarial system. It's sort of an inquiry where the judge makes sure that all the evidence comes into the record. Coming to part number B, whatever procedure or manner which the judge might decide to take, he should make sure that it does not prejudice the other party or treat the other party unfairly. Thank you.
Thank you very much. Thank you, Honorable Chief Justice. I'm done.
Thank you, Chief Justice. Good morning, Mr. Mpeo.
Thank you, Commissioner. Good morning.
There are some good things which are said in your papers here. None of the appeals against your judgments have been upheld. You don't have any reserved judgments over 6 months. You don't have any parted matters. Sorry, you don't have any reserved judgments over 60 days. You don't have any parted matters over 6 months. Your case clearance rate is good. Your writing and analytical skills are satisfactory. You know your procedural law. That's very impressive. But here is the thing. You scored 14 out of 30 on substantive labor law. So your labor law knowledge is not so good. Are you prepared to go to the Labor Court?
Thank you, Commissioner. I will concede that when I took the written interviews, I had not yet enough time to prepare. I had been in regional court for more than 10 years. So I was still trying to refresh my mind on what I learned when I was still at college. So I think that's the reason for that poor performance. Thank you.
But can we trust that if you were to go to the Labor Court, you would up your knowledge of the Labor Court sufficiently?
Yes, Commissioner. I would read around the cases, also read the acts and consult with the colleagues. Even after the first interviews, I started reading around. Thank you.
You are currently studying towards your master's degree, are you?
Yes, Commissioner, but I put it on hold due to financial constraints.
When do you think you'll complete that, and what's your dissertation on?
Thank you. The dissertation, I am now at part 3. That's when I put it on hold. As soon as funds permit, I intended to do it next year. I tried to do it this year, but I was also constrained with finances for my children who are now all at the secondary school.
I'm interested in knowing what you are specializing in with that LLM.
It is specializing in corporate law.
Thank you, Chief Justice. I have no further questions.
Thank you, Chief Justice. Yes, thank you, Chief Justice. Mr. Mpewa, good morning.
Morning, Commissioner.
Yes. You seem to have a problem with judgment writing. I have a comment here from one of the judges who review your judgments, say that Mr. Mpewa needs to perfect on the application of law to the facts. In some judgments, he does not cite direct applicable legal authorities. Why is that so? Would you comment on that?
Thank you, Commissioner. I would state that in instances where I might not have cited direct legal authority, I would have taken it that they are not in dispute. The parties would be agreed on the position of the law. So I was of the view, I think that is wrong. I'm